Abusia eye Chema Wontumi MPP Ashanti Regional Chairman. Abeto just say on the 20th of this month, the final judgment day. Now, after Ochina announced 20th July, their Exim Bank and so ejinem next week. We dear mammy Cassa, one mammy Cassa, yet, say your court, na yeti and Kumaya about mountain. Efa Chema Wontumi ho. Emra se ha. That's why I bear media editor. So I said. Ube subscribe at the amount mobile notification bonus for podcast updates. Now be sure so at the amount say bear media GH so in near tap. And need no blue coin so in near tap. A yard drain and I chere. I want you who and any away social media so most especially all cases are all alleged cases and it be about a besom. Now a ya abusuya would say a seminar. My bomadi and some chere margin. Na nya atem didie eni die no bu kwan so enye atem didie that's why be media just papa sakonya bu sado biara ase abusuan for since day one one am support to your channel dey am here be do sabe person say mama yenko na yinti fresh update abeto bia efa eye Chema Wontumi ya me yadom on the 20th of July ye ba be di na asem mama yinti na yencho ya adwe masisi a ye da ase
Chema Wontumi ne final judgment ne Monday 20th as in bank so next week me de ho bebro na abusua ni nyina ne se frame screen so ne yini nkomo me ba chawo wasi Wontumi that is Wontumi 18th July or try Sunday Monday 20th asem wasi Wontumi seek Supreme Court intervention as Akonta mining trials nears judgment. Me cry me raho because asem no TVCBC Monday na Chema Wontumi court edena hye na me boa Monday ya ochinechi edi enimo ya Chema Wontumi ko face trial abusua court Supreme Court say omo hyeram judgment ni ya Monday omo intervene mano abusua ayaro osem abusua Chema Wontumi enyo happy man and me cry no I fear for him. But fast forward and Edwidita Tamaklo Godwin. Yes, MP boss. Or boy my pa. Yen go no or a council and some more kafacha mount to me case no. Na absha or bompire Bobby Macha to me. Stay tuned.
Mampon, any way, I say more. Maji airways no. At the abomo.
Ya boy, you bend the kakakra. Maba wuncheya. Yewra Chema Wontumi versus the state, the republic. Wasem edie ewanimsem. Wama kan sem no akodu baabi na court ni say obi am filing addresses. Wamo filing addresses na wana ni lawyer Yewra and the appear could be say one of the niema be a course so up to the time so obi am filing addresses no what tia see ye watwe ne ho e de film e ti watwe ne ho di film a kiki no a ye benya Yewra atachia say wono na ababesom wono so pray court no say oma ne bre mani wem na onfan tro addresses no said this and now what and the court no can say on or before 13th of this month atwamu na what your addresses in the koya yensaka bie the yensaka bie no the woman ne say was niema bi wo wa here constitutional interpretation enti ebeya court ni stay judgment na eba so Monday no na o stay court na a judgment eba so Monday na no court no akọ Supreme Court over the interpretation of certain provisions a Minerals and Mining Act in wadaruma na yenye adisua ewomwe wey eye bibia eye normal practice yen jurisprudence mu anase wey bibia eye alien to more practices and rules ni ade
yo bra kwame there be the American and is a hard case makes good law. But So, you know, harder. That's when the law develops. Okay, who say one of the things at a personal level, make I say a man me NCA matter no. And I'm here counsel for the second accused, the then DG, former DG for National Communication Authority. No. A similar thing is here. Emma, at a point, not the way I not try no air corner. I didn't like it. In China, me application and call before the judge. Manchama and Yoma are ended. The first time almost first prosecution witness, I mean, who said one or two things air corner. One aja made applications now started airba. Inti nyame yadom ema judge no ehwe because that time no near kokota tema sebio prosecution witness for the document the ba right there and there na judge say counsel, do you have any objection to the tendering in of this document through prosecution witness one? After my court, my client, in open court, I could be found as a client. Document where I'm seeing it the first time. Do you want me to raise any objection to it? Is it something that we can rely on? Is it something that is authentic? So the whole thing looks bizarre. Because even in criminal civil trial, there are no surprises. In Tobacco, now it has said immediately, for application, I mean, my Lord Justice, stay back for.
Counsel.
Yes, sir.
Where the boy metwasia senkane any document be any doubt to be wa sabrana prosecution no ho na defense no so e wo na wo mu di asem maybe case management level kra no bi wa esese afani nyina eti asem bo
no correct. When we say section 6 of the Evidence Act NRCD 323 I say admissibility objections should be taken at the time the evidence is being offered.
Maybe I try section 7 is here.
Section 6 of NRCD 323.
Okay. But me kind
Ghana higher friend of the Evidence Act.
But me kind is here. Says the Evidence Decree 1975 NRCD 323 section 6. In every action and at every stage thereof, any objection to the objections admissibility of evidence by a party affected thereby shall be made at the time the evidence is offered. Shall
mandatory. Mandatory.
Yeah.
You know, me sana msedabi adi me kana yuansa makasa na beli. It's why me kai standing and me friend me other lawyers no because there were other accused persons say hey before this is what I want to do because the way I know my kono yanhwe ya yehuni into wana ada me application me the judge name me by Tuesday na sa case me here Tuesday Thursday into you go Tuesday and up 10 and upon 2 p.m. 4 hours into every week be an 8 hours solid into me say and I said I didn't encourage me to an amount in a me 2 years. Thankfully my Lord Justice came back for a court of appeal judge now. Over the wisdom in it, I'm a catcher and say, my Lord, me say, oh, an idiom. Try ye. Yan sheni ya. Yan as lawyers, you may be a client in trouble. Quality legal representation as you and far more. Yes, me far more. Because section 6, I need to take an objection.
Okay,
because this is the time we are offering the evidence. Now, I am not seeing the document. If the government is make me take a proper objection on a document I'm seeing the first time.
Na Bajawasaka says to every objection to the admissibility of evidence shall be recorded, ruled upon by the court as a matter of course.
Absolutely. Don't come in. I go back, no. My law is okay. Application here, there. And then he said, look, Article 19, Fair Trial Rules, may say, an accused person should be given reasonable opportunity to prepare his defense. It is one American say, my Lord, with the greatest of respect. The Constitution and the use of that word, reasonable opportunity to prepare the defense, no. That prepared defense, no, a very broad concept. The European Union, this particular provision, no, the 1992 Constitution, we are taken from other statutes.
I call the 19 was all the idea was say one no say a person charged with criminal offense.
No,
19.2. A person charged with criminal offense shall in the case of an offense other than high treason or treason, the punishment for which is death or imprisonment for life, be tried by a judge and jury.
2C.
2C, okay. Be presumed to be innocent until he is proved or has pleaded guilty.
Now Yenko D.
D. C. Be informed immediately in a language he understands and in detail of the nature of the offense charged.
Fantastic. Now G. G,
okay. Okay, G say, be afforded facilities to examine.
Wait. Be afforded what?
Facilities. To be to examine in person or by his lawyer the witness called by the proceeding before the court.
Afforded facilities to examine. That word, afforded facilities. You can't catch a court then say, Constitution using the word afforded facilities to examine. It includes documents. Facility no yet ni pankwa. It includes documents. The examination of those documents, you know. Okay. What means for mommy to see and cast me examine? It may can say the 1992 Constitution in use of the word facilities to examine, no, it includes let me know ahead of time what you have so I can do proper examination.
And mommy surprises be in court.
No mommy surprises be two. Rakwame. Me know neko. What you are buying? I wouldn't say buying here strong, mighty. I buy no echo. Now I buy a keep it documents. Baba no say. I buy document, no. In the last minute, what the other spring you on me. And also the heading of that constitutional provision, then fair trial. And
say na I was say fair trial, yes.
Fair trial. Now, how can that trial be fair? And what time or you are blindfolded me? It doesn't make sense. Even though at that time the attorney general of that time, Madam Gloria Kufu, any the team ever court. And Brana me moving my application. Almost said there be minimum crimes and mechanism no there be the Criminal Procedure Act at 30 has only 2 forms of trial.
The whole Chief Justice in the
No, Attorney General.
Attorney General, in any case is a case of national interest,
Yes, yeah, Mami Gloria Kufu. So she was in court, she was announced just that my law lecturer, my criminal procedure lecturer, Madam Evelyn Kilson, on the opposite application. So that be Adia Mede Bano, that is not how the criminal trial system is there be because there are two modes of trial. And
procedural, the only ban is defective and now say
no, the only ban that is not the law. Parliament, Parliament created two modes of trial: summary trial and trial on indictment. Now, say a trial on indictment, they would have disclosed the documents and the evidence they have. But because it's a summary trial, no, the Act 30 does not give them that. And I said, no, Act 30 was done in 1960. I'm talking about 1992 Constitution and the provisions in the 1992 Constitution. If you want me to use Act 30 as the basis to say there is no such thing. Thankfully, the judge in question, my Lord Kebafor, saw the wisdom in what the prayer had made. If you want to look, only me arguing. But since maybe meaning Article 130, Article 19, 2G, no. In a Attorney General also can say, the American, that is not how it is, no. That day, make I say, make us not tell me so, but Mr. Tamaklo, you do know that Article 19 is a human rights provision. So as a judge sitting here, I have the mandate under Article 33 to enforce human rights provisions. Now, Mr. My Lord, if you look carefully at Article 132, that's Article 132, then they are on. And they are law.
Article 132, me come as is here.
Article 132. They are called laws.
But Article 132, the what one where an issue that relates to a matter or question referred to in a clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
So that's it. And see, Article 132, they say, 1992 Constitution, emma the Supreme Court exclusive original jurisdiction to interpret the Constitution. However, it can happen, say, as a also in the district court, circuit court, court of appeal, and now say, at the way Senator at the High Court, what I say, or even Court of Appeal. Now, a combat say, there is a matter going on at the High Court, Court of Appeal, Circuit Court, District Court. Now, the parties involved, but the parties involved, are raising an issue. Clearly, you can see that there is a genuine interpretation. High Court and now Court of Appeal are saying no AC, so men to Anamobia, Jinawa, Nasa system no bra, young Supreme Court for honor. Now, the Supreme Court, a interpretation every year. Sabi you. At that time, no, ye the bebrewo na wetuhu anamo. Yakame, mekai say yen law firm. Ye represente Zoom Lion. Auditor General, charge Zoom Lion. Say, Sikabia Yetuama Zoom